Welcome back to Counting to Five, a podcast about the United States Supreme Court. I'm Mike, your host, and this is our weekly YouTube live stream being broadcast live Thursday, March 15th, 2018 at 9 p.m. Eastern Time. The live stream will also be posted as an episode of the Counting to Five audio podcast. And if you're watching live, please feel free to ask questions in the YouTube live chat at any time, and I'll try to monitor that and periodically answer any questions as they arise. The weekly podcast, the weekly live stream, we try to keep up to date with the latest Supreme Court news, what's been going on at the court in the past week, and what's coming up next week. So here's what I plan to cover today. A little later in the live stream, I'm going to preview 3 cases that are set for argument on Monday through Wednesday of next week. I'm also going to talk briefly about a 4th case that had been scheduled for argument but has just a few days ago been removed from the March argument calendar. But before we get to that, let's start with the latest news from the court, starting with 2 death penalty stay applications this week. So there were 2 executions scheduled for tonight, March 15th. And when there are executions, that pretty much inevitably means last-minute stay applications to the Supreme Court in an attempt to get the execution postponed or eliminated. One of the executions tonight was in Georgia, the other in Alabama, and I'll talk a little about each of these 2 cases. The Alabama case was a man named Michael Eggers, who had been convicted of a murder in the year 2000 of a former employer. It was a pretty brutal killing by beating and strangulation, and there had been litigation over the years in this case. In 2015. His federal habeas corpus petition was denied. So this was in federal district court. His former counsel filed an appeal. However, Eggers filed his own handwritten motions to the court, asking the court to terminate his counsel and asking the court to dismiss the appeal. The court later had a competency hearing for Eggers to determine whether he was competent to do what he was asking, competent to waive his appeals. At that hearing, he said that he withdrew and waived all his future appeals in their entirety, and the judge ruled that he was competent to do this. The judge, this is a quote from the district judge, Eggers has made a rational choice to dismiss his appointed counsel and abandon his appeal. Eggers has the right to make that decision, provided he is competent to do so, and the evidence indicates that he is. So, as far as Alabama sees it, the district court found him competent to waive his rights to appeal, and basically that's the end of the matter unless his attorneys can show that the judge was clearly wrong in this determination of competency. Now, his attorneys filed their stay application at the Supreme Court, kind of giving a different take on Eggers and his actions, and they discuss his apparently his long history of paranoid delusions. They say that Eggers for years has believed there's been a wide-ranging conspiracy against him, that this conspiracy caused him to commit the murder that he's convicted of, and that this conspiracy is very wide-ranging, including various government officials and including his prior and current attorneys. And as a result, he has repeatedly been since his conviction, he has not wanted to be represented by counsel. There's been a few different attorneys that have represented him, and he's periodically requested that they not represent him because he has no trust in his attorneys. And his attorneys say that he has made these types of requests to the court multiple times, that he requests to the court that he be executed, that he give up on all his future appeals and he be executed. According to his attorneys, that's happened no fewer than 9 times. But they say that they asked the court to kind of look past this and say that what's really going on here is you have a delusional client who really wants to represent himself. He wants to be represented. He wants his defense to center around these claims of persecution and conspiracy, and what he really wants is to be able to raise those issues. It's not that he wants to be executed. And they argue that when he has routinely resumed his litigation after these requests that they just go ahead and execute him, and that shows that he really, it's just his frustration with not being able to litigate on his own terms. However, as Alabama points out, since this competency hearing, he has been pretty consistent in asking for expedited execution and rejecting any assistance from his attorneys. And so that's kind of the state of his application to the court. Now, this stay application was denied earlier this evening, and that execution did go forward at about 7:30 p.m. tonight. Now, just as a side issue, this is in Alabama, and if you've been listening to these weekly live streams, you may remember that just 3 weeks ago, this is the same state that had what's been described as a botched execution of Doyle Ham. He was set to be executed 3 weeks ago, but the execution was aborted late into the night when the state was unable to find a usable vein for lethal injection after multiple attempts. But they went ahead tonight with the execution of Eggers. Eggers had not brought any sort of a cruel and unusual punishment claim in this court, so that wasn't at issue in this case. So that execution did go forward. Now, the second execution scheduled tonight, this is out of Georgia, was a man named Carlton Geary. Now, he was convicted as a serial killer. He was actually referred to in the press as the stalking strangler of Columbus, Georgia. And he was convicted in 1986. He was convicted and sentenced to death for the rapes and murders of 3 elderly women. However, he was believed to have committed a number of additional similar crimes, at least 11 and possibly more similar attacks, of which at least 8 ended in deaths, as well as a few survivors. And these happened in upstate New York, where he had previously lived, and then later in Georgia, the Columbus, Georgia area. Now, his claim that he brought before the Supreme Court is an actual innocence claim. He claims, his attorneys claim that he is actually innocent of these crimes, that he was misidentified as the serial killer, and the attorneys have raised various claims about DNA testing that they say excludes him from certain of the crimes, and the state the state's theory was that all of these crimes were committed by one single person, and they could show that he was at least as to one of them, that he was excluded as the perpetrator. They also bring claims about the government's destruction of evidence that they say could have provided additional DNA evidence to show his innocence. Now, the government comes back and basically just disputes very heavily this attempt to disclaim responsibility for the murders, and they go through DNA evidence that ties him to multiple victims in different crimes, fingerprints left at multiple different sites, the killings which had very, very similar circumstances, and tracked his movements from city to city through 3 different cities, and also that he tied himself to the locations of some of the murders by admitting to burglaries in certain locations, and so it's basically just a factual dispute between the two sides. There's additional in press reports about Carlton Geary. There's also information of additional match since he's been in prison to an additional murder that was not originally included among those that he was tied to at his original trial. So according at least to some sources, the case is even stronger than the evidence that was available. The cases that were tied to him at trial, but that's the basic idea. It's an actual innocence factual claim. Now, as of the start of this live stream recording, the court had not yet taken any action on that stay application, so that was still an open stay application, and as far as the latest news accounts, the execution had not gone forward yet. So that's just one. It's a wait and see what's going on with that, and it's very possible that soon, possibly by the time this live stream is over, that will have been resolved one way or the other. But as of right now, that was still a pending application. Now, if you've been listening to these weekly live streams, you'll notice this is a recurring topic has been these death penalty stay applications, and I've been covering each of them as they come up, partially because despite the kind of low profile of this as compared to the court's the argued cases, the court's the main kind of docket that everyone thinks about as far as the Supreme Court is concerned. These death penalty cases are just a routine and recurring part of the court's work and make up a significant part of the court's workload, especially since these are typically last minute emergency applications that kind of may require justices to just drop everything on short notice and really focus on these death sentences. So, I think it's worth covering these because that kind of the role they play in the court's work has to inevitably shape the way the justices view capital punishment, and it's been cited by some commentators as a theory behind why certain justices who had been on the court for considerable period have turned increasingly against capital punishment as they've been on for a long period of time. And one theory behind that is that the kind of relentless stream of these stay applications on death penalty cases wears down on them over time. So it's just an interesting, less prominent aspect of the court's workload. And of course, occasionally, one of these stay applications turns into an argued case on the court's merits docket. One example of that was the case of Madison v. Alabama. It's a cruel and unusual punishment case. That was there was a stay application that we discussed on the live stream back in January, and the court did stay that execution and then later granted that case, and that'll be argued in next year's term, so probably in October next year. So that'll be a full argued case. So occasionally these death stays turn into real cases on the court's docket with longer term impacts. So moving on from that, just want to talk quickly about a few other developments at the court. One is not a legal development, but just another milestone. So today, March 15th, as we record this, is Justice Ginsburg's 85th birthday. She is the oldest current member of the court. At 85 years old, she's also currently the sixth oldest serving justice ever. That includes the older justices include the oldest two were Oliver Wendell Holmes and John Paul Stevens, both of whom retired at age 90. But she's up there as one of the oldest ever serving justices. And interesting, just little comparison. She's actually only 3 years younger than Justice O'Connor. Justice O'Connor turns 88 later this month, so she's only 3 years younger than Justice O'Connor. Justice O'Connor retired from the court more than a decade ago, but Justice Ginsburg is still there and still at it. Justice Ginsburg is, I believe, at present she's the most active public speaker of all the current justices on the court. She's been on a public speaking tour lately, has made appearances in various cities all over, and she makes clear that she really enjoys her high public profile, and she's expressly said many times that she has no intention of leaving the court anytime soon. She has said on many occasions that she intends to keep doing it as long as she feels that she can do the job full steam. But as she gets up there in age, eventually it will no longer be her choice, just inevitability, and this birthday milestone kind of just brings that to public attention once again. But moving on from that, one other development, a case that was had been scheduled for oral argument. There's a case called Salt River Project Agricultural Improvement and Power District v. Tesla Energy Operations. Now, this is a case. It's kind of a technical case about the right to appeal certain decisions in antitrust cases, and this was a case that was brought by Solar City, which is wholly owned by Tesla, the car company. Solar City brought this action against the local power district, which is a government entity, and they brought this antitrust action. Now, government entities are immune from certain antitrust actions under something called the state action immunity doctrine. Now, the court in this case, the district court, denied the government's motion to dismiss on state action immunity grounds, and the government appealed this decision. So appealed that denial. They said that this case should have been thrown out because they were immune. Now, the question that this case raised to the Supreme Court was just a procedural question. It was the question of whether this denial of immunity was immediately appealable. Now, there's a rule in the federal courts. Normally, only what's referred to as final judgments are appealable. So it's kind of intermediate decisions during the course as a case kind of works its way along in trial court. Intermediate decisions aren't appealable. It's only when it's final, when it's something that would decide the case finally, that's appealable. There are some exceptions for certain immunity decisions, something called the collateral order doctrine. And so the dispute here was whether this falls within those exceptions and whether this was appealable. So it's just kind of this, just a technical procedural issue. And it had originally been scheduled for oral argument on Monday, March 19th, so this upcoming Monday. However, just last week, so Thursday, March 8th, there was a joint letter from counsel for both sides in this case, where they informed the court that they were basically deep in settlement discussions and attempting to work toward a settlement of the case, and that a settlement of the case would result in the dismissal of the lawsuit. So the court reacted to that quickly on Friday. The court removed this case from the March argument calendar. On Monday, this case was added in to the April argument calendar. So they took it off March's calendar, moved it to April. They added it to a day that had 2 arguments already, made another 3-argument day on the April calendar. But I think the expectation right now is that these parties are trying to settle this case, and that likely this case will be gone before April rolls around. But that remains to be seen. The settlement discussions could always potentially fall through. So as we get closer to April, we'll see if this case disappears completely or remains on the argument calendar. So that's about it. It's been pretty quiet at the court this week. The court has been hasn't sat for a little while. So there have been no big orders lists, no new cases granted in the past week. So that brings us to oral arguments. Oral arguments resume next week for the first week of the March oral argument sitting. And it's a light week. They originally had, as I said, 4 cases granted, but since one of those is now off the calendar, they only have 3 cases. So it's a light oral argument week. But I'll walk through each of those 3 cases on the calendar. And again, if anyone has any questions, please leave them in the live stream at any time, and I can try and address them as I go. So the first case of the week, the Monday's case, is called Sveen v. Mellon. Now, this is the underlying dispute in this case is about a life insurance policy and who's the beneficiary of a life insurance policy. But the legal issue that this case raises is a very unusual one. This is a case brought under the contract clause of the U.S. Constitution. I'll come back to that in a minute and explain why that's a very unusual claim. But first, just really briefly, here's the facts of the case. It's very simple. So this involved a couple, a Minnesota couple named Mark Sveen and Kay Mellon. And they married in 1997, and in 1998, Sveen added Mellon, so his wife at the time, as the beneficiary on his life insurance policy. Now, so that was 1998. Now, fast forward to 2007. In that year, Sveen and Mellon divorced, and then a few years later, in 2011, Sveen died. Now, at the time of his death, his ex-wife was still listed as the beneficiary on his life insurance policy. He had made no changes to the policy, and she was still listed as the beneficiary. Here's the wrinkle that's added to this case. In 2002, so that's 2002 is after this couple was married and after the wife was added to the life insurance policy, but before the divorce and death. So this is in 2002. Minnesota passed a law that's referred to as a revocation on divorce law, applying to life insurance beneficiaries. And what this law does, and these laws exist in a number of states, is they say that upon a divorce, the ex-spouse is automatically basically removed as a beneficiary on a life insurance policy. And the theory behind this law, the kind of the policy idea behind a law like this, is that many people never take the time to update insurance beneficiary information after they have a policy created. The theory is that the theory is that most people who get divorced probably don't intend to keep their ex-spouse as a beneficiary. So the state wants to create a new default rule that's intended to better track the actual intentions of most life insurance policy holders who are divorced. Now, this doesn't. This is just a default rule. So now this can be overridden. So if someone gets divorced, but they want their ex-spouse to remain as the beneficiary of a life insurance policy, then they just by re-adding that beneficiary after the divorce, that would override this, and then they would remain the beneficiary. Also, if the policy had specific language that said that even in the event of divorce, this won't be changed, that would override that law. And also, if there's a specific divorce decree from the court in the divorce settlement, that would override this. So it's just a default rule in case no one has taken any of those specific actions that says that when the divorce happens, the spouse is just removed as a matter of law as a beneficiary. So as a result of this law, Sveen's children, so it's Ashley and Anton Sveen, argued that they should be actually the beneficiaries of this life insurance policy and not the ex-wife. And again, this approach is a pretty common approach when it comes to life insurance. There's, depending on how you count, somewhere in the ballpark of 26 to 28 states that have a similar law. And similar actions are taken by courts in an individual case-by-case determination. So courts will sometimes determine that the life insurance, even in states that don't have these laws, that the life insurance policy holder would not have intended to keep that person as the beneficiary. And there's also this is talking about life insurance policies, but there's a very similar rule for wills, for beneficiaries of a will when a will is left to a spouse. And there's a near universal rule across the states that that if someone has not changed their if a will is drawn up during a marriage and is not revised after a divorce, that there's an assumption that the spouse will be removed as a beneficiary. And in fact, this Minnesota statute is based on something called the Uniform Probate Code. And the uniform codes these are projects. There's quite a number of them, but they're basically efforts by experts in various fields of law to create kind of best practices statutes, model statutes, in the hopes that these will be adopted by states across the country and create kind of a degree of uniformity from state to state. And this particular the Uniform Probate Code, this particular provision, the Minnesota statute was based on a provision of this Uniform Probate Code, and that same provision has also been adopted by many of the other states that have a similar law. So the point of all this is just that the Minnesota law here is a pretty standard approach. It's not universal, but it's a pretty standard approach. It's not an extreme outlier. Now, note there is a counterpoint to this policy argument, and it showed up in an amicus brief filed by the Women's Law Project who filed a brief along with a number of other, mostly women's organizations, women's rights organizations. And that brief actually argues against this on policy grounds, arguing that revocation on divorce statutes have a disparate impact on women for the reasons that men are more likely to be higher wage earners, they're more likely to carry large insurance policies, they're more likely to have employer-sponsored life insurance policies and things like that. Women are more likely to have women have longer life expectancies and are more likely to be the beneficiaries who collect on these policies. And by putting these in place, these laws are generally detrimental to women. And they further argue that the assumption that it's based on that people would not want the ex-spouse to remain as a beneficiary on their life insurance policy is based on what they describe as kind of outmoded assumptions about divorce. They argue that there's increasingly amicable divorces, and that people may want to provide for an ex-spouse for the reason of protecting children that they have with those spouses. So, they argue on a policy grounds that this assumption is not a good one and doesn't make sense. So that's just to kind of present the other side of the policy. But as I said, it is a very common approach that many states take. So here's where the problem comes up in this case. That law, as I noted, was enacted in 2002, which was after the insurance policy was already in place. So the claim that's being raised here, this is a claim by Mellon, who's the ex-spouse. The claim is that this law, when applied retroactively, so when applied to policies that were written before the law was put into place, it violates the contract clause of the Constitution, the U.S. Constitution. Now, the contract clause, the relevant portion of the contract clause, it says, "No state shall pass any law impairing the obligation of contracts." And the argument here is that this is impairing the obligation of contracts in direct violation of this clause, and therefore is unconstitutional, at least as applied retroactively. So I'm going to step back and give kind of a brief, real quick history of the contract clause. So the contract clause is part of the actual Constitution. It was prompted by concerns about debt relief laws that were passed by various states during the post-Revolutionary War period and the Articles of Confederation period, and these were viewed by many as irresponsible policy, and that hurt the credit worthiness of the states by eliminating certain debts that had been incurred. And the idea was that this contract clause, this prohibition on impairing the obligation of contracts, would help to promote investment by making contracts more secure. People would feel more secure about not having their debts canceled. And during the early period of the United States, this was enforced by the court. However, starting in the late 19th century, there were increasingly court-made exceptions to the contract law clause. And the key case here is a 1934 case called Home Building and Loan Association v. Blaisdell. So now this is 1934, so this is during the Great Depression. And what happened was the law at issue in this case was a state moratorium on mortgage foreclosures. And the court upheld that. It was justified in part as an emergency measure, and partly because it was temporary. It was a temporary moratorium on mortgage foreclosures. The argument at the time was that this was an economic emergency, and in order to stave off just more devastation from just rampant foreclosures, that this moratorium was necessary. But it was viewed by many as largely eliminating the contract clause as an effective barrier to the state infringement on contracts. And basically, at this point, the rule was that the contract was okay if the legislation's addressed to a legitimate end and the measures taken are reasonable and appropriate to that end. That's some language from the court. So this doctrine kind of developed over time. The modern test is a three-part test, asking first whether the law causes a substantial impairment of contract rights, And then so if it's not deemed a substantial impairment, then that's considered not a violation to begin with. But if it causes a substantial impairment, then the question is whether the law serves a significant and legitimate public purpose. And this includes things such as the remedying of broad and general social or economic problems. And it asks whether the means of serving that purpose are reasonable and appropriate. And it's considered to be a pretty forgiving test. It's considered to be a test that doesn't have a lot of force in restricting state action that may impair a contract. So the arguments here is the contract clause argument has a couple pieces to it. First, there's an argument from the original meaning of the contract clause, and this is a direct attack on this Blaisdell 1934 precedent, arguing basically that case should be overruled or cut back, arguing that the original understanding of the contract clause is clear and obvious. There's a long history of case law, and also comparing it to other restrictions in the same portion of the Constitution, part of the same provision. More of the sentence, which includes the contract clause, actually says that no state shall pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. So that the other provisions of that clause are still enforced fairly strictly. It's only the contract clause portion of that has been watered down. The argument is, and the argument further is that the modern doctrine, that three-part test I described, allows basically the exact type of laws that the contract clause was intended to prohibit. And it allows favoring particular political interests at the expense of private parties' contractual rights, which was the motivation behind the contract clause. So that's this kind of originalist argument, and it's a pretty bold argument, arguing basically for overturning case law that goes back to 1934. It's a pretty broad, bold argument. But beyond that, the Mellon, who's challenging this under the contract clause, argues that if the court's not willing to go that far, that they should at least strengthen the doctrine somewhat. One method or one means would be to place private contracts between private parties, like this insurance contract, on the same footing as contracts with the state. Right now, the courts do have a higher standard to allow the state to impair its own contracts, and this is motivated in part by concerns about opportunistic self-dealing. If the state is going to enter into contracts with a private party and then pass laws that change the terms of that contract that it's a party to, so there's kind of higher standards, and they also finally make the argument that even under the modern contracts clause doctrine, this should be struck down as going too far. The argument is that the government interest here is pretty minimal. This is just a default rule. The government is not doesn't claim that it has an interest in preventing insurance payments from going to an ex-spouse. They're just changing the default rule, and also that they presented the government has no empirical evidence of policyholder preferences that would justify this new default rule, and so this is just not a significant and legitimate public purpose. And they also argue that under the criterion whether this is a substantial impairment of the contract rights, they argue that this provision, by canceling removing the named beneficiary of the policy, directly alters the core subject matter of a pre-existing contract. So this is not just some minor feature of the contract. The whole point of a life insurance policy is to provide money to the designated beneficiary, and that's what's being changed here. So they say that even under the modern doctrine, this just goes too far. On the other hand, the Sveen, and this is the children who are seeking to have this law enforced, they have a number of arguments about why this should be deemed okay and not contrary to the contract clause. And first, they make some kind of practical arguments. They say that this legislation is really not targeted at contracts; it's targeted toward divorce proceedings. And they say that divorce courts routinely exercise power over beneficiary determinations, even in the absence of statutes like this. And this is just setting a default rule for how divorce courts, how these courts are going to treat these contracts. The counter argument to that, on the other hand, is that the contract clause is it's well settled. The contract clause applies only to legislation, not case by case judicial determination. So these are just two different things. It's not they shouldn't be compared. That's the argument on the other side. Another argument for why this is okay is the Sveens. They argued that the obligation is not actually impaired. They say that it says the contract clause protects against impairment of obligations, and they say the obligation here is on the insurance company. It's the obligation to pay money, and the insurance company still has that obligation. So this is not like a debt cancellation. This is not getting someone out of paying money. It's just designating a different beneficiary. And also, they argue that it's just a default rule that's easily overridden. So the only real impairment here is just requiring a little bit more paperwork, and just the requirement to file a little additional paperwork to keep a beneficiary designation is not a severe impairment. They also argue that the retroactive application of this doesn't really have any real reliance interests. No one was entering into a life insurance policy depending on the fact that if they got divorced, it would still go to their spouse. Nobody's thinking about that when they're entering into a life insurance policy, and the fact that they can always change the beneficiary at any time means that there's not a real strong reliance interest. And they argue that actually the reliance interest should be seen to run the other way, given that this law was in effect in 2002, and by the time Sveen died, this challenge came after his death. So Sveen had every reason to believe that the revocation law would take effect, since that had been in place since 2002. And if he had looked into this, then he might have he would have known that his beneficiary designation under this revocation law would no longer take effect, and that might have induced him to not bother to take the time to change the beneficiary. That's kind of the argument they make there. And they also argue that just this doesn't really implicate the special interest concerns that motivated the contract clause. There's no there's no interest group or political faction that's motivated to that's on one or the other side of this particular case. So those are some of the basic basic arguments. There's a lot of arguments going back and forth, but the big question here will be whether there's any interest in the court on the court in reconsidering its contract clause precedent. Is there anyone on the court that's interested in this kind of very the radical step of reconsidering the Blaisdell 1934 precedent, or in some way narrowing the doctrine, or will this be just a narrower case about the correct application of the modern contract clause doctrine? So that's what remains to be seen in this case, as it's argued next week. So let's move on to Tuesday next week. And the second case the court will be hearing is called National Institute of Family and Life Advocates v. Becerra. This is the highest profile case of the upcoming week. And because it touches on the always contentious, always hot button issue of abortion. And this is a First Amendment challenge to the California's Reproductive Fact Act. Now that act, the FACT Act, it imposes certain disclosure requirements on what are referred to as crisis pregnancy centers. Now these crisis pregnancy centers are pro-life centers that, among other things, counsel women about alternatives to abortion. So the party in this case, National Institute of Family and Life Advocates, or NIFLA for short, is a nonprofit pro-life organization whose members include pregnancy centers across the country, but including about 130 pregnancy centers in California. And the law involves two different categories of these centers. there's what's referred to as licensed centers. Now, these licensed centers are medical facilities. These are licensed medical facilities, and they generally they provide certain like prenatal medical care. So they may have things like pregnancy testing, prenatal vitamins, ultrasound examinations, other types of clinical services. Notably, they do not provide contraception or abortion-related services. And they also may provide other non-medical services as well. But those are the licensed facilities. The other category are what are referred to as the unlicensed facilities. Now, these are centers that provide a variety of services to pregnant women, including pregnancy test kits, also maternity clothing, baby clothing and supplies, educational materials, prenatal or parenting educational materials, things like that. But they don't provide actual medical services, and they're not a licensed medical facility. So the Reproductive Fact Act is a California law that was enacted in 2015, and it imposes disclosure requirements, different disclosure requirements on the licensed and unlicensed crisis pregnancy centers. So the licensed crisis pregnancy centers, for those, it requires a disclosure notice, and this disclosure notice has the following language. It says, California has public programs that provide immediate, free, or low-cost access to comprehensive family planning services, including all FDA-approved methods of contraception, prenatal care, and abortion for eligible women. To determine whether you qualify, contact the county social services office at, and then the phone number is provided. And it's required that this has to be conspicuously posted in large type in the waiting room or provided individually to each client at one of these licensed crisis pregnancy centers. The unlicensed crisis pregnancy centers, there's a different requirement for those. They're required to have a disclosure that says, this facility is not licensed as a medical facility by the state of California and has no licensed medical provider who provides or directly supervises the provision of services. And that notice has to be at the entrance to the center, in the waiting area, and this is important, it has to be included in any advertisement for the services of that crisis pregnancy center. And one fact that the petitioner, the pregnancy centers make a lot of in this is that has to be included in every what are referred to as the threshold languages. So those are foreign languages spoken by a sufficient number of people in the county in which this center is located, which in some county, in Los Angeles County, apparently there's up to 13 different languages that this notice would have to be listed on, and that would have to be included in every advertisement for these pregnancy centers. And these disclosures have to be provided in large or more prominent text on the advertisements. Now, a crucial fact that also comes up in this litigation is that there's an exemption from these disclosure requirements for facilities that participate in California's Family Pact program, and that's a state program that participation in that program requires facilities to provide contraceptive services, and due to the nature of those services, none of the pro-life facilities participate in this Family Pact program. So there's an exemption that applies to a lot of facilities that you could describe as pro-choice pregnancy services, but because of their non-participation in the Family Pact program, the exemption would not apply generally to pro-life organizations. So the basic issue in this case is that the pregnancy centers argue that this is compelled speech that's in violation of their First Amendment rights. They're being forced to convey a message to their clients that's at odds with their beliefs. A lot of this case comes down to very different framings by the two sides of what's really going on here, what's the facts at issue. So these crisis pregnancy centers, they argue that basically this Fact Act represents hostility by the lawmakers, the state of California, toward the pro-life mission of these centers. So they argue that basically this is just an attempt to undermine charities that are providing free services to pregnant women, just solely on the basis of hostility to their pro-life mission, and that they've specifically designed this law to target pro-life organizations and either compromise their mission or severely limit their ability to advertise themselves to customers. But the framing by the supporters of this FACT Act is quite different. They argue that in fact these crisis pregnancy centers are engaged in deliberately misleading conduct, and they say that there's a routine practice of crisis pregnancy centers of by through their language and through the way that they design their clinics into deceiving women into believing that they're entering a facility where they can be provided with a full range of reproductive health services, including perhaps abortions and contraception. And basically luring people in on these false assumptions or false premises, and perhaps making them believe that other services are not available when at a different facility those abortion services would be available. So they argue that really the purpose of this FACT Act is to counter this deceptive and misleading behavior by the crisis pregnancy centers. The legal arguments in this case run along a few different tracks, and one of the most interesting ones that'll be interesting to see, because it's an area that's not really well fleshed out in the Supreme Court's case law, is the concept of professional speech. So the argument is made by supporters of the FACT Act that in many contexts the government requires professionals as part of a professional client-provider relationship to provide certain information as part of the provision of services. And they point to things like attorneys who have various disclosure requirements to clients about fees and other things, and also medical informed consent laws, where physicians, before providing any of a large number of different services to patients, must give informed consent. Must obtain informed consent, which means providing certain information, which is sometimes specified by the government, the information that they're required to provide. And the issue here is that this professional speech concept, as a kind of an exception, a special category of speech, is not really well defined by the Supreme Court's case law. And lower courts have recognized this as kind of a distinct category of speech and have pointed to certain Supreme Court cases as supporting that. But the Supreme Court itself has not really defined or explained the scope of this. And there's arguments made by these pregnancy centers here that the court should not do that, that their existing case law treating professional speech is just as protected as other types of speech is sufficient and shouldn't be changed. They also argue that to the extent that there is a different treatment of professional speech, it's only in much narrower contexts where that language is tailored to the particular professional relationship and professional expertise being conveyed by doctors or lawyers or other professionals. And here it's just generic advertisement of state services that are provided elsewhere. So they argue that this just doesn't fit under that professional speech category. There's also an argument by the supporters of the FACT Act that this should be viewed as commercial speech. Now, commercial speech is a category of speech which does receive First Amendment protection, but it's a kind of a lower level than fully protected speech. And usually, commercial speech, it refers to language that's advertising or proposing a commercial transaction. The argument is made here by the pregnancy centers. This can't be commercial speech because there's no commercial transaction taking place. These services are provided free of charge. There's no money changing hands. So this is non-commercial by definition. The argument on the other side is that commercial and transaction should be viewed more broadly as the types of provision of service, advertisement for provision of service, whether for a fee or not. So there's that argument. And then there's also an argument about the framing of how targeted this policy is, and the state and the supporters of the FACT Act argue that this is basically it's this disclosure requirement is just neutrally targeted based on characteristics of pregnancy centers, and it's based on the state's interest in making sure that people who are attending centers that don't have the full range of services that are available at some places in the state are informed that these services may be available elsewhere. But on the other side, the senators argue that this is viewpoint discriminatory, that this is specifically targeted at pro-life clinics, and the criteria for the application of these requirements was specifically designed so that this burden would only fall on the pro-life clinics who were specifically disfavored by the legislators who were passing this legislation. So a big issue in this case will be the framing. What kind of lens the justices view this case through, and how they choose to characterize what's really going on here in this case, but something that definitely to watch is the professional speech argument, and whether the court takes this as a opportunity either to flesh out the contours of a professional speech category, or perhaps to reject that categorization entirely. So that kind of sums up what that case is about. And the third case, briefly, on Wednesday next week, is the Upper Skagit Indian Tribe v. Lundgren. Now, the Upper Skagit Indian Tribe, I apologize, I don't know if I'm pronouncing that correctly, but it's a tribe located in Washington State. And basic background is this tribe, under a 1855 treaty, they gave up their historical traditional tribal land, but in the last several decades they have been gradually buying back what was formerly tribal territory, and the intent is to have this. There's a process by which recognized Indian tribes can have land taken into trust by the federal government, and then that converts it to sovereign territory of the Indian tribe. And so their intent is to gradually buy back tribal land and have it taken into trust by the federal government. And since the 1970s, they've bought back about 500 acres, mostly contiguous land. Now, this case concerns a parcel that the tribe bought in 2013. And this is part of the historical area that this tribe inhabited, but it has never been part of any formal reservation territory, or it has never been held in trust by the government for the tribe. Now, the southern neighbors of this particular parcel are the Lundgrens, who are the other parties to this Supreme Court case. And the issue here is that on the near the southern property line of the that divides the Indian parcel, the parcel at issue that divides their land from the Lundgren's land, near that southern property line, but some ways north of that property line, there is a fence that runs roughly parallel to that southern property line. Now, the Lundgrens have owned their land, adjoining land, since 1981, and it has been in their family since the 1940s. They believed that they owned the land all the way up to that fence. And they say that they and the prior owner of this land, before the Indian tribe purchased it, had all treated the fence as the dividing line between the two properties. After the tribe purchased the land, they wanted to remove the fence, clear cut down to the property line, and erect a new fence on the property line reflected in the deeds. And so what happened was the Lundgrens, to prevent this, brought a adverse possession claim. They raised an adverse possession claim against the tribe. They brought a action to quiet title. So, real briefly, adverse possession is a legal doctrine that says that when certain requirements are met, when someone is in possession of land that they don't have formal title to, but certain requirements are met, then they can obtain ownership of that land. And there's a few different requirements that have to be met. The most one of them is that the possession of the land has to be open and notorious, which just means that they have to be openly using or possessing that land. It can't be secretly using or occupying the land. It has to be visible and open that they're doing so, and it has to be for a continuous period of time. And this varies from state to state. It's usually in the range of 10 to 20 years. I believe it's 10 in the case of Washington State. But they brought an action on a quiet title action And a quiet title action is just a legal action to resolve competing claims on a particular piece of land. And the court will look at the competing claims to a piece of land and try and definitively determine who has what rights to that land once and for all potential claimants. So they brought this quiet title action, arguing that under a claim of adverse possession, they actually own up to the fence. And what happened there is that the tribe argued that they have sovereign immunity, which prevents them from being sued or being brought into this quiet title action. Now, sovereign immunity is a legal doctrine that says that a sovereign government is immune from legal process, so they can't be hauled into court, and it applies in various different contexts. In a sovereign's own court, generally any sovereign government, this goes for the United States government, the governments of states, a sovereign can't be sued in its own courts unless it gives permission, unless it specifically waives its immunity by, for example, passing a law that says people can sue it for certain things. But also it applies in the context of, for example, foreign governments. So a foreign government often can't be sued in U.S. courts. If you have a grievance with a foreign government, you may not be able to sue them. The particular details vary, but often they can't be sued. Now, Indian tribes under American law, they're recognized as separate sovereigns. They're referred to as sovereigns that predate the Constitution. They're often referred to as what's known as domestic dependent nations. So they're domestic. They're part of the kind of United States system. They're under the protection or control of the United States federal government, but they do retain this inherent sovereignty that they had that pre-exists the United States Constitution. So they do have sovereign immunity. It's not disputed that Indian tribes in many contexts have sovereign immunity. So here's the argument at issue in this particular case. The Lundgrens argue that in this case, this quiet title action is something known as an in rem action. And they argue that in these in rem actions, sovereign immunity does not apply. Now, what does this mean? So a normal lawsuit, the typical lawsuit that you think of, are what's referred to as an in personam action. And that's an action that's brought against a particular person or a particular legal entity. And the court is asserting jurisdiction over a specific person. So if it's Smith v. Jones, then the court is saying, is asserting its authority to find liability for Jones in that case. But some actions that relate to property are referred to as in rem actions. And the idea there is the court is asserting jurisdiction over the specific property at issue. And this may be physical land, it may be personal property. This in rem is often used to refer to bankruptcy when you have an estate that's being divided between various parties. And the idea is that an in rem action allows a court to assert jurisdiction over specific property, importantly, including land that's located within the jurisdiction, the territorial jurisdiction of those courts, to exercise control over that land and to resolve all disputes in kind of a final form without worrying that they need to individually have jurisdiction over every last party that might have some related claim. And the argument here by the Lundgrens is that generally other sovereigns are not immune in rem actions in state courts. So other states or even foreign governments can be brought in to an in rem action. For example, if this property in Washington State were not owned by an Indian tribe, but were owned by the government of Oregon or some other state, or a foreign country, Canada, for example, then they could be brought in on a quiet title action to resolve the ownership dispute over this land. They argue that the Indian tribes should basically be treated the same way. They say that this is kind of a long-standing common law exception to sovereign immunity. And they say that the Indian tribe shouldn't have superior rights in this circumstance to, for example, another U.S. state. The Indian tribe, on the other hand, argues that this is just the wrong way of looking at this. They say, in fact, exceptions to sovereign immunity, which includes the exceptions for these in rem actions, is not a matter of court-made common law. It's a matter for Congress to decide. When you look at the foreign sovereign immunity in rem actions, there's a specific exception under statutes passed by Congress that allows that to happen. And the Congress has authority to pass statutes that specify what that Indian tribes' sovereign immunity is waived for certain purposes, but they've never chosen to do that in relation to these in rem actions. And they say that it's not, it's actually consistent with other areas where Indian tribes actually have broader immunity than some other actors. So, for example, Indian tribes can be immune for actions related to their commercial activities, where, for example, foreign governments are not immune when they're acting as a commercial actor, not as a sovereign. So it's not inconsistent that here, where Congress has not specifically made an exception, it's not inconsistent to believe that the Indian tribe actually may have a broader degree of immunity in this particular circumstance. So that's the basic arguments here. So the court is going to have to just look at this in rem sovereign immunity issue and decide whether there is some kind of inherent common law exceptions to sovereign immunity, or whether this is really something for Congress to tackle, which it has not at this point done. So that's it. For those are the three cases that are going to be argued next week, and that kind of brings us to the end of this live stream episode. The next live stream will be a week from today, Thursday, March 22nd, again at 9 p.m. Eastern Time. And that's our usual weekly live stream time, Thursdays at 9, but you can always check the Counting to 5 YouTube channel to find the next scheduled live stream. Now, next week's live stream, there may be a lot going on. Tomorrow, that's Friday, March 16th, the court has its private conference, and that means on Monday morning, the court will be issuing an orders list at 9:30 a.m. Sometimes there's some interesting orders come out on those orders lists, and it could include new cases granted for next term. So we'll just have to wait and see Monday morning what comes out of that. It's also possible there could be additional opinions in argued cases released next week. If that does happen, it will be most likely be on Tuesday at 10 a.m. right before the oral argument for that day. But again, we won't know. They generally announce Friday afternoon if they expect to be issuing opinions the next week. So we don't know yet whether there'll be any opinions next week. So we'll see what comes out of that. But there's also again, the three cases that I just discussed will be argued next week. In next week's live stream, if there's anything particularly interesting in oral argument, we may touch on those. But I'll also be previewing next week. I'll be previewing the second week of March oral arguments. And there's currently 5 cases scheduled between Monday, March 26th and Wednesday, March 28th. The highest profile of those cases is a case called Benisek v. Limon, which is a partisan gerrymandering case out of Maryland. So we'll be talking about those cases next week. There's also one execution scheduled currently for March 20th. So again, that will likely involve some last minute filings, and always a possibility of other emergency orders or interesting developments. So that's kind of what's on tap for next week. Whether you're watching on YouTube or listening to the audio podcast, I'd love your feedback. You can leave comments on the show notes at countingto5.com, on the Counting to 5 YouTube channel or Facebook page, tweet at countingto5, or send an email to mike@countingto5.com. Please subscribe to the Counting to 5 YouTube channel or audio podcast to make sure you don't miss any future episodes. And thank you for listening. This has been Counting to 5.